Honorable Superior Court is now open and back in session. Good afternoon, Your Honor.
Good afternoon. Please be seated. Thank you. Are you ready to proceed?
Yes, Judge.
Bring the jury out, please.
What's the exhibit letter number? Just stand up, Judge.
Would counsel stipulate, please?
Yes, Judge. Yes. So before the break, Officer Kimball, we were going to show you a couple of videos, and I think now I'll just show you them from this is from the surveillance at from 1 Jefferson crossing across the street.
Okay.
I'll get it. I can do it, yeah. There. Takes about 30 seconds. Right, and for the record, this is from exhibit, before you play it, this is from exhibit KK. And you're familiar, you already saw you've shown us some of the videos that were taken from the Ring doorbell across the street from 1 Jefferson, correct?
Yes, correct.
And this is one for the record. It's marked as video 3 on this exhibit, but the time you'll note in the bottom right-hand corner is May 24th, 2019 at 7:21 and 9 seconds in the morning. You see that there?
Yes.
All right, so we're going to play that, please. Could you pause it for a second? Now, we're pausing it at 7:21 and, well, we'll just say at second 20 to the left there on the orange line there. I'll first note, this was you'll recall, May 24th was a Friday, correct?
Correct.
And we see that the garbage pails are out in front of both 1 Jefferson and at 4 Jefferson Crossing, right?
Correct.
So by this time, you were aware that garbage pickup day was Friday in this part of Farmington, right?
Correct.
Okay. Good, play it, please. I'll call your attention to the vehicle that is now pulling in across the street. You see that, right?
I do.
And you determined that that vehicle belonged to Kent Mawhinney, is that right?
I didn't determine that.
Nobody in your department determined that that was Kent Mawhinney's SUV pulling
Well,
in?
it's consistent with Kent Mawhinney's SUV, yes,
Okay.
but
And
definitively,
it was not consistent with a Ford Raptor, was it?
no.
It was not consistent with a Chevy Suburban that was owned by the Ford Group, right?
Correct.
And it was not consistent with a rental Yukon, right?
No.
Okay.
But the Yukon wasn't rented at the,
Of course, but I'm just pointing out that it was not one of the Ford Group or Dulos vehicles.
yes, correct.
Okay, can you play the rest of it, please? Okay, and I'm going to show you one other video. This was Ms. Troconis said that she came back to her house after dropping off her daughter to school, correct?
Correct.
To school. All right, so now we're at, pause for a second, and we're now at, for the record, May 24th at 8:01 and 54 seconds. Same date. Can you pause it, please? The vehicle that we're pulling in at now at the exhibit is at 45 seconds if we're looking at the line from the left there. Is that the vehicle that's consistent with the white Cherokee that's one of the 4 group vehicles?
It is, yes.
Okay. And pause again for a second. Now, there's a pickup truck driving by. That pickup truck that's caught in this particular image is not related in any way, to your knowledge, to either the case or to the Dulos home, correct?
That's correct.
Okay.
Correct.
It's just a truck driving by.
Yes.
Okay. Okay. Now, also just before the break, I asked you whether or not you had indicated as part of your affidavit regarding the arrest of Michelle Troconis in September for the car wash, the washing of the Tacoma, whether you mentioned in that warrant that Michelle had said words to the effect of, well, obviously, when asked by you why she thought Dulos would be washing the Tacoma, her reply was, well, obviously, all the evidence says, because you showed me the picture of the blood in the door, it's because the body of Jennifer at some point was in there, unquote. Do you remember
Yes.
that being your language?
Yes. Now that
Okay,
you-
I found this, do you need to see it now?
No.
You know that's what it says, right?
Yes.
Okay, so let me just be clear. There was never any scientific laboratory analysis that determined that there was any blood on the door of the Tacoma, correct?
My understanding is that there was the presence of blood, but the DNA profile was not developed. So we don't know whose blood it was.
So let me get this straight.
Again, I'm not a scientist.
Are you sure that, based on what you're saying, is that in fact the lab did not test nor find any blood on the door of the Tacoma when it was tested by the state lab?
I am not sure, to be fair.
You did not write in any report that blood was found on the door of the Tacoma, did you?
No, I did not.
Now, with regard to the what you had indicated to Michelle regarding the findings of the laboratory personnel from what was recovered at Wells Lane in New Canaan, By now, you had much of the DNA analysis by August, correct?
Correct.
And you were also aware that the only place that there was the location of any mixture of blood that contained any let me withdraw that question and ask it a different way. You were aware that by August 13th that there was a mixture of DNA found on a faucet that may have included Fotis Dulos with another person, correct?
Yes.
And the other person was believed to be Jennifer Dulos's DNA found on that same faucet, correct?
Yes.
But you never were able to determine how the DNA got on that faucet, correct?
No, I don't determine how it gets on. I just
Just that it
read
was
the
a fact
laboratory that it was present.
that it was present, okay. But by now, you also had spoken to the individual who was the supervised visitation custodian, correct?
Dennis Puebla or Sidney Streeter?
Sidney Streeter, right?
Yes.
And you knew that Mr. Dulos had a picnic, sort of, you want to call it a picnic, had dinner at the house, correct?
Yes.
And that, in fact, he had interacted with his wife on the 22nd, right?
Yes.
And he had interacted and played with the children, right?
Yes.
When we were here on Friday, we watched a number of videos of the comings and goings of the vehicles from 80 Mountain Spring, correct?
Yes.
You were asked to narrate, if you will, some of the exhibits and some of the time frame of the vehicles coming and going.
That's
right?
correct.
Were you also aware that there was an image of the Tacoma leaving the 80 Mountain Spring property at approximately 5:30 a.m. on the 24th?
Was I aware
Yeah,
when?
when you were interviewing Michelle on August 13th, 2019.
I don't remember when we determined, but when we saw that video, so I can't answer that.
All right. You didn't ask her any questions about that travel or transportation or that vehicle on that morning and that day, did you?
We're talking about the Tacoma?
The Tacoma leaving 80 Mountain Spring Road at, looks like around 5:30 in the morning on that day.
I don't think we had that information, so I didn't ask her specifically about that.
Well, didn't you?
Leg.
I thought when you were here on Friday, we watched a bunch of back and forth from 77 Mountain Spring Road, and you narrated that.
Yes.
Had you seen any of that by the August 13th, 2019?
I'm just going to pose an objection. I don't believe that that particular video was played. I
That's
could be, it
Well,
could be wrong,
well,
but I don't think it was.
It's up to the jury's memory as to whether it was played, and the objection is overruled.
I'm sorry, could you read?
Yes. Had you seen any of those videos that we watched on Friday from 77 Mountain Spring Road when you were interviewing Michelle Troconis on August 13th,
I had-
2019?
I had seen some of them, yes.
But not the one where the vehicle is leaving at 5:30 in the morning of Tacoma?
I don't believe I had seen that at that point on August 13th.
In any event, you had no information of anyone arriving during the night of May 23rd, no, withdrawn. You had no information of anyone arriving in the night, beginning in the night of May 24th, 2019, to 80 Mountain Spring Road before the Tacoma left the property. Is that correct, as of the August 13th interview?
Well, someone would have had to arrive in order to drive the vehicle out.
My question, did you see any video of anyone arriving?
No.
And I'm not sure I asked you this question. If I did, I apologize. You were aware that the 77 Mountain Spring Road surveillance cameras were continuous, or was that stop action?
I'm unaware of that. You did ask, and I'm unsure
Okay.
whether they're motion activated or not.
You didn't see any cars entering before 5:30 in the morning, that early morning, did you?
On the 24th?
Yes.
No,
You didn't see any bicycles entering, did you?
no,
You didn't see any pedestrians entering, correct?
correct.
There were a number of questions about Fotis Dulos leaving the house to go buy meat. Do you recall that part of the interrogation?
I do.
And in fact, your department confirmed surveillance of him going to the Stop and Shop and going in, right?
He was present at Stop and Shop during that time frame. Yes.
And there was also a time on the evening of the 23rd before getting to the Stop and Shop, where he stopped again at 80 Mountain Spring. Isn't that true?
That's true.
And this was, I think the discussion you had with Ms. Troconis was about a dinner party at their house on May 23rd, correct?
Correct.
And him going to 80 Mountain Spring Road, and it was in the Suburban that he
It
traveled?
was in the Suburban, yes.
And it had a roof rack on it?
The Thule wreck, yes.
And then the same vehicle was seen at the Stop and Shop parking, right?
Yes,
And he was seen going into the Stop and Shop, right?
that's correct.
And buying something,
Correct.
and then traveling back up to sometime after 6 p.m. to Fort Jefferson Crossing, right?
Yes.
And by the way, you did interview prior to August 13th, 2019, the people who had been at the dinner party at the Dulos home on the evening before, right?
Again, I don't remember the specific dates that those interviews were conducted. We may have done that prior to the 13th of August. I don't remember what dates they were interviewed.
And they were certainly, just their names, I'm not going to ask you what they said, but you talked to Stephen Reich,
Correct.
his then girlfriend, maybe now she's his wife, I don't know, Beth Johnson,
I didn't speak to her. I'm not sure if someone else did, but I know I didn't.
Mr. Haynes, Robert Hutch Haynes, the owner of the water skiing thing, right?
He was interviewed at some point, yes.
And his wife, Erin, right?
Correct.
And they all were talked about in the video, weren't they?
They were.
You asked a few questions about Kent Mawhinney during this interview, didn't you?
Whether I asked or Detective Clabby asked, but yeah, there were questions asked about Kent.
Now, were you aware when you were questioning Michelle on August 13th that there was a phone call between Fotis Dulos and Kent Mawhinney while he was out of the house, going to the Stop and Shop?
Were we aware? I believe that was on Mr. Dulos's phone records, so yes.
And to your knowledge, Mr. Mawhinney wasn't a guest at the dinner party that night at the house, was he?
To our knowledge, no.
Incidentally, when we showed you that video a few minutes ago of the vehicle consistent with Kent Mawhinney's SUV arriving at Fort Jefferson Crossing, were you ever able to determine when his vehicle left from any of the surveillance?
From the surveillance?
Yes.
I don't believe so.
Again, because it was motion activated, right?
I think we determined that through the Phone records.
It would only, from the Mawhinney's phone records.
Phone records.
Right. But in any event, the only time you would get the video is if, like I said, there was some movement that would trigger.
In the foreground of the ring, correct.
And that would be true whether it was somebody coming or going, whoever it was, right?
Yes,
It didn't capture every time a person arrived or departed, correct?
correct.
And it also didn't show all the times or necessarily when there might have been other times that a fire was in the fireplace, would it?
You're saying there could have been more fires than were shown?
Yeah.
That's absolutely true, yes.
Let me just ask you some questions regarding what was asked on August 13th that you related back to the June 6th interview at Attorney Bowman's office. You had, on that occasion, so that everybody recalls, it was not just you and Detective Clabby, correct?
On the 6th, yes,
On the
correct.
6th. There was Sergeant Ventresca was there, right?
Yes,
He was even then your supervisor on this investigation, correct?
yes, throughout he was.
And there was I forget her name, there was a
Detective Allison
female
Peters.
detective?
Detective Allison Peters.
And for part of the time, State's Attorney Colangelo was present, correct?
Yes,
And for those who don't remember, he was the state's attorney for this district here, the chief law enforcement officer, right?
yes.
And on that August 13th, during that August 13th interview, you brought up some of the things that Michelle had said, or at least you claimed she had said, on June 6th. Isn't that right?
Yes, during the 8/13 interview, we brought up some material from the 6th of June, yes.
Did you say on August 13th to Michelle that you didn't want her to bring up the timeline that she had written? Didn't you tell her that?
I'm sorry, which?
On August 13th, didn't you tell her you didn't want her to bring up her timeline again?
I don't remember saying that on August 13th, no.
Did you say it on any of those occasions?
I believe I said it on June 6th.
Oh, so, well, let me just be clear. Is that the time that you said that if she brings it up, you've been instructed by the state's attorney to leave, correct?
If she starts going down the timeline, that was the instructions from the state attorney.
Okay,
But
and
we
you didn't
didn't- we
just make
didn't
that
leave.
up. Was that just you saying that, or was that the actual instruction you had?
No, I did not make that up, that was the instruction.
That was an instruction. Okay.
But we didn't leave, even
No,
though
I
she went down
understand.
the timeline.
Even though she did bring it up, right?
Yes,
And you brought it up at some times too, according to what we just watched, right?
yes,
And you showed her Fotis Dulos' timeline, right?
we did, yep.
And she had said previously she hadn't seen his version, right?
She said during the second interview on June 6th that she had not read Fotis's timeline.
And you gave her a copy on August 13th. So in the video, we see her reading it, right?
Yes, Detective Clabby shows it to her.
And she didn't say she had seen it before you showed it to her on June 6th, did she?
Did she say? Just ask that one more time, I just want to make sure.
She never said she had seen it before you had shown it to her on June 6th, did she?
No, no.
What she said was that Fotis Dulos was trying to tell her certain things to say, like he was saying things out loud that he was hoping she would include, right?
Which she did, the shower, in her timeline.
But he put stuff on his timeline he had nothing to do with that was on Michelle's, right?
Yes, your client completed her timeline, he completed his.
And you don't know in time frame when he put in all these extra things after she left, as she said, to go to the Enterprise rental car to bring in her vehicle or get a rental car,
It's
right?
gonna object, assumes facts not in evidence, Judge.
Well, the question is, essentially, when the defendant went to Enterprise Rent-A-Car concerning, we'll call them items in the timeline that, and this is how the court understood it, were not there when she left, that were there when she came back. And the question is, counsel,
The question is, Michelle never said that she saw Dulos add anything to his timeline that he had copied from hers. Did he? Did she?
and the objection, and the court's not sure that was the question.
It was not the question, Judge. I'm not sure.
The previous question, which I rephrased based on Your Honor's question, was whether or not Dulos may have added stuff to his timeline after she left to go to the Enterprise rental car.
So the question is, does this witness
Yeah.
know whether Fotis Dulos added something to his timeline
Right.
after Michelle Troconis left to go to the Enterprise Rent-A-Car? Is there an objection?
So based on that, Judge, I would object to foundation, lack of personal knowledge. I don't know how you know that.
Well, the question is, does this witness know whether that occurred? So overruled.
I do not know that.
And in fact, during this third interview, Michelle did not say that she provided information to Mr. Dulos to add to his timeline, did she?
She added information to her timeline that he said.
Right, so my now question is the reverse. She didn't tell you that she volunteered information to Dulos that he should add to his, did she?
She said she recited information which he then put on the timeline.
Did she say she saw him putting it on the timeline? She never
She
said
said
that.
obviously he wrote what I said, so I don't know when he wrote it.
Oh, okay. That's the point. You don't know when he wrote it, right?
Correct, I don't know. But it ended up on the timeline.
And just to also remind the jury, the copy of Michelle's timeline was a photocopy that you had retrieved from 4 Jefferson Crossing, right?
That's correct, yes.
And the original you knew had been given to Andrew Bowman, her attorney, right?
No. No, she did a separate timeline for Attorney Bowman, or she completed the existing timeline.
Well, let's be clear. Let me remind you, during the second interview, did Mr. Bowman confirm that the original of the photocopy you had been given to him, and he nodded his head, and he had it right there on his folder on June 6th?
So to clarify, Counselor, he had a timeline. I don't know that that was in fact the same timeline that we had a photocopy of.
Right, but you don't know that it wasn't either, do you?
She was asking, we were trying to find out where in the house her timeline was, and she couldn't tell us.
Didn't
Because it
she
was a
specific-
photocopy.
Didn't she specifically say she gave it to Andy and nodded to him in that June 6th interview? Does that refresh your recollection?
It wasn't clear, so she may have said that.
By the way, had you reviewed Pavel Gumieni's interview with Detectives Butin and Allegro prior to the August 13th interview with Michelle?
Yes,
You in fact mentioned that Pavel had, quote, told you a lot, unquote, words to that effect, in this
that was
particular-
Detective Clabby that said that. It was said in my presence.
All right, but you had watched the video or read the transcript? What did
I had
you-
read the report.
Of what Gumieni said?
Yes.
All right. And were you aware that during that interview with Gumieni, that the detective, specifically Detective Allegro, point blank asked Gumieni if Dulos had ever referred to his wife as a fucking bitch or words to that effect?
Not aware of that.
And were you aware, though, that Pavel at that time said no, he had never heard that?
Well, I'm just going to object, Your Honor.
Well-
Relevance, hearsay.
At this point,
It-
counsel is asking the witness about another interview in which this witness did not participate. He's asking him, was he aware? Now, that phrase, were you aware, often is used to get in evidence that would be inadmissible. So essentially, we have hearsay on top of hearsay.
Except I'm not offering it for the proof of the statement that was made. To the contrary, Your Honor, it's that words were used that were suggested to Mr. Gumiani.
Well, it appears to this court that it is being offered for the truth of the matter asserted, that Michelle Troconis never used those words. So in this court's view, it is being offered for the truth of the matter asserted. It's hearsay sustained.
By the way, you never heard Mr. Gumiani say that Michelle ever uttered words like that, did you? Back when you were doing the investigation?
No, I did not.
Even in the third interview on August 13th, didn't Michelle tell you that she had assumed that he was home because his phone was there, that Fotis was home because the phone was there?
What she said, my recollection was, well, obviously he wasn't, well, probably wasn't home.
Probably wasn't home.
Probably wasn't home.
But she had said she'd assumed it because she saw his phone there, right?
She said she had thought that he was home because Kent was there. Didn't understand that one.
Okay, well, didn't she also tell you, didn't we see this in the interview, that Fotis had told her that he had a meeting with Kent Mawhinney coming up on Friday?
I know that she said that in the August 13th interview. I think she said it in an earlier interview.
And she never contradicted that, though, did she? She never took that back, did she?
No,
And you knew, in fact, Kent Mawhinney was at the house that morning, right?
yes. we knew
And
that.
we saw his vehicle, a vehicle consistent with his SUV, pull through the archway into the back parking area of Fort Jefferson Crossing that morning, right?
That's correct, yep.
And we don't see the vehicle in any of the time action videos leaving, correct? At no particular.
Not that I know of, no.
Right. And just for the record, you also arrested Mr. Mawhinney, correct?
He was
Subsequent.
arrested, not by me, but yes, he was arrested.
By the way, you also were aware that the next-door neighbor at 2 Jefferson Crossing had video that captured all comings and goings and any movement on the street, correct?
So that individual had one, and then he had a secondary camera that caught some of the movements. I'm not sure if it was activated, motion activated or not.
Did you
So I don't
or
know if it
one
was
of the...
all of it.
I'm sorry.
So I don't know if it was all of the movements.
Okay, so you or one of your members of your team did review whatever surveillance video came from 2 Jefferson Crossing, correct?
I did not, but it was reviewed, yes.
And none of those cameras showed when Mr. Mawhinney left or when a vehicle consistent with Mawhinney's SUV left that morning, correct?
I honestly can't speak to that. I don't know.
Okay. By the way, until Michelle volunteered on August 13th that she's the one who picked up the phone when she saw a number from Greece, you didn't know who had picked up the phone, correct?
She saw the name Andreas, and she picked up the phone, and we didn't know. We only knew the phone had been answered.
Right. And I believe that you had determined there was a 16-second call from Andreas Tsiartas from Greece, right?
I believe that's correct, yes.
And she's the one who said it was me, I picked it up. Isn't that what she
Yes,
told you?
Yes.
She also told you that Fotis often stored other women's names under men's names to disguise the fact that he was talking to other women. Didn't she tell you that?
She did.
And when you looked at his phone, you determined that some of the names that looked like men were in fact registered to women, right?
I didn't look into that aspect, but I can't speak to that.
Did anyone in the department look into that?
Perhaps, I don't know the outcome of that.
By the way, you never talked to Andreas Tsiartas, correct?
We tried to, but he didn't want to cooperate.
Didn't he come into the United States from Greece like a month or two later?
He did.
And you did not speak to him at all? Or
No.
nobody from the department did?
No.
By the way, was his phone seized?
It was?
Did he ever admit he's the one who sent that short meme that we saw the other day?
Well, Judge, I'm just going to object. The detective just indicated.
I'll withdraw it.
This witness wasn't going to cooperate.
Right.
Sustained.
I'll withdraw that. By the way, to your knowledge, did the Tsiartas phone get seized?
Did it get seized?
Seized, yes, when he came to the United States.
Like I said before, yes.
Was ever returned to him?
He never asked for it back, is what I heard.
There was a lot of questions asked in this real estate, in this August 13th session about the Realtor coming on Saturday, correct?
Yes.
And I think
Rania.
Rania, and her, just for the record, we're talking about, that was going to be my question. You mentioned Rania, but her last name is Manusis, right? Or Manutis.
I believe so, yes.
And she is a registered real estate agent in the Farmington Valley,
I
correct?
believe so, yes.
And there were a couple of times when either you or Detective Clabby talked about how 80 Mountain Spring Road was an important location or aspect of your investigation. Remember saying that?
Yes, it was.
And just to be clear, the evidentiary services unit of the Western District Major Crime Squad went with the evidence van to 80 Mountain Spring Road, correct?
Yes,
They spent at least an entire day going through the entire house, right, over that weekend?
they went through the interior of the house, that's correct.
And didn't they also go through the around the exterior as well?
I'm not sure what they did as far as the exterior goes. I know that, I'm not sure what the van did as far as the exterior goes.
But you also know that subsequently, there were also dog canine units on the property?
Yes,
And in fact, at one point, they went in with some kind of device to look for shallow graves and whatnot that might have been dug on the property, right?
correct.
Did you're aware that there was a coffee cup thrown away in one of the recycling buckets inside the house at 80 Mountain
Just
Spring Road,
object,
right?
Judge, hearsay.
Now, again, this is the were you aware questions. The fair question is whether or not either this witness or other police witnesses found a coffee cup at 80 Mountain Spring Road. But the question, were you aware that X happened? What's going to sustain that objection?
All right, I'll ask it a different way. When you asked Michelle Troconis about whether or not she saw evidence of coffee on May 24th when she was at 80 Mountain Spring Road, were you already told that there was in fact, a used coffee cup in the blue recycling bucket at 80 Mountain Spring Road?
Objection, hearsay.
Well, again,
It goes to this witness's actions.
the question is, were you told that there was a coffee cup in the garbage at 80 Mountain Spring Road? Well, court sees this question as, and the court is anticipating the response to the objection, that it's not being offered for the truth, but the court thinks it is being offered for the truth, that there was a coffee cup in the garbage at 80 Mountain Spring Road. Sustained.
All right, well, let me ask a different question. What evidence did you have a knowledge of that was found evidence that was used in this investigation, did you find at 80 Mountain Spring Road that you were in possession of when you were questioning Ms. Troconis on August 13th, 2019?
Judge, I'm just going to object hearsay.
Well, the question is, what was found at 80 Mountain Spring Road? That's the question.
Yeah.
Overruled.
The evidence that we were operating on was the to and from activity, to and from 80 Mountain Spring, and the Toyota Tacoma specifically.
Yeah, my question is, at the location itself, not people driving to and from, what evidence was found at 80 Mountain Spring Road during the course of your investigation prior to your interrogation on August 13th?
I believe we found any,
Nothing, right?
not in the interior. It was all happening in the driveway.
What did you find in the driveway?
I don't know that anything was found in the driveway, but we found,
She told you that she had brought over cleaning supplies to 80 Mountain Spring Road, right? On August 13th?
yes.
Did anybody seize any, to your knowledge, any cleaning supplies at 80 Mountain Spring Road?
Well, at 80 Mountain Spring Road,
Right.
we found some in the garbage in Albany Avenue, which may have been at 80 Mountain Spring Road at some point. I don't know.
Of course, I didn't ask you that question, sir.
Okay.
Right? Let's just talk about what was found at 80 Mountain Spring Road.
No cleaning supplies were found at 80 because
No garbage bags were found there, were they, at 80 Mountain Spring Road?
I'm not sure if any garbage bags were found at 80.
No Clorox or other cleaning spray was found
No,
at 80 Mountain
that's
Spring Road,
correct.
right? You asked a number of questions as I watched this video the other day on Friday about whether or not she was cleaning windows. Do you remember that portion of the testimony when you were asked questions about it and we watched the video?
Yes, I remember that point in the interview.
All right. At no time, and I just want to be clear, at no time prior to August 13th, 2019, did Michelle Troconis say to you that she was washing windows at 80 Mountain Spring Road, right?
That came from Pavel, but yes, in none of the interviews did she say that.
She said you said you had proof of it and you were going to play a video, remember?
I do remember saying that, yeah.
And then we listened to some audio rather, that was played for her, right?
Yes,
And that part said, whatever was played, said nothing about her washing windows, did it?
no. It was an entirely different topic.
This past Friday, you did say that was a mistake, correct?
Yes, I did.
On your part.
Yes.
Nevertheless, after you played this unrelated audio clip, didn't she say that maybe I did and I'm sorry if I said that?
About the windows?
Yeah.
Yes, you did.
So you convinced her that she had said that even though she hadn't, right?
Objection, Your Honor, mischaracterizes the testimony, mischaracterizes.
Cross-examination,
Overruled.
right?
I don't know that maybe is a statement of conviction.
Didn't she say that, didn't you say, you definitely said you were cleaning windows, that's why we're asking you why you're not saying that now? And in response, I'm sorry if I said I was cleaning windows. Isn't that what her response to you was?
Well, I'm going to object, Judge, because that's way out of context. He should read the entire thing if he's going to do this exercise.
Well, the question has already been asked whether or not the witness's statement to the defendant essentially convinced her that she said she was washing windows or not washing windows. In other words, the statement made by the witness convinced the defendant that she said something that she didn't say. That's the question,
Yes,
rather than go through the transcript.
that's fine. Let me ask, isn't that correct? That you told her she was definitely washing windows, and she said, I'm sorry if I said I was washing windows.
Judge, I'm going to object. That is not the sequence as I recall it.
Well, there's redirect, overruled.
Question in one piece, if you would, Counselor, please.
Did she or did she not say to you after you played that clip, unrelated clip, I'm sorry if I said I was washing windows?
Between the time of me saying you were washing windows and that statement,
Yeah,
yes, she did say that
okay.
with a lot of interim information.
Now, you also swore under oath, did you not, in another statement, that Troconis repeatedly told investigators she had been, quote, cleaning windows, unquote, while at 80 Mountain Spring Road? Didn't you swear to that in an affidavit?
You see that?
Sure, I have to mark it for ID.
Okay.
Counsel. And I want to indicate, you wrote another affidavit in January of 2020, correct?
Yes,
And so that was after you had an opportunity to review the recordings and the videos of all three interrogations, correct?
after I had an opportunity, yes.
Yes.
I was going off of notes, wasn't watching the videos themselves.
But when you swear to something under oath, you have to be pretty sure because you're saying something as being true, correct?
Yeah, definitely.
Well, I'm going to object, Your Honor.
I haven't
because-
shown it to him yet, Your Honor. There's nothing to object to yet.
Well, respectfully, I think that the question, Your Honor, frankly, was related to the third interview, and that document does not relate to the third interview. So I think it's improper impeachment at this point. But if counsel wants to show it to the witness, I have no objection.
What's the question again?
The question is, did you not swear under oath that Troconis told investigators that she had been, quote, cleaning windows while at 80 Mountain Spring Road? Did you swear to that in an affidavit? And you asked to see the document, and I'd like to show him what's been marked as LL for identification. I'm going to call your attention to this bullet point right here.
Okay, I see that.
So did you, under oath, swear that she had repeatedly said that she had been cleaning windows at 80 Mountain Spring Road?
That appeared in my affidavit, yes.
That was an error, a mistake, correct?
Yes, absolutely.
You wouldn't consider it a lie, though, would you?
No.
Yes, on Friday, you were shown a couple of videos where you pointed to some smoke coming out of the chimney of the house, correct?
Yes, correct.
And you're aware that that was a chimney connected to a fireplace in that house, right?
Yes,
In the video, you referred to it as billowing smoke,
Well,
correct?
just object, Judge.
grounds.
Again, it mischaracterizes the video. This witness did not say this.
Well, the witness can speak for himself.
Very well, Judge.
Overruled.
I don't remember saying billowing, I remember saying presence of smoke.
Was it Detective Clabby? You said there was billowing smoke?
In the third interview?
Third interview.
I believe it was.
Okay. And whatever it was, you pointed to what you had looked at prior to the August 13th interview, right? The other day. That's what you were referring to, right?
I was told about the presence of smoke.
Oh, you didn't see
I
it?
hadn't seen it.
You had only seen it, what, last week? Was the first time?
No, it wasn't last week, but it was not prior to the 13th of August.
Okay, all right. And she told you that she had firewood in the fireplace. Didn't she tell you that?
In the interview?
In the interview, yeah.
She did say that.
And she told you about other times that she had had fires going in the fireplace, right? In the same time period, right?
She had multiple fires that day, is that what you're referring to?
No, didn't she tell you she had one for her mother, that she had another one the previous day? Didn't she tell you that?
Yeah, she said she had them every day, and then she said not every day, but she did allude to a fire with her mother.
And she even asked and told you that Pavel had helped her bring firewood up to the porch, didn't she? In this interview?
That he had carried wood.
Carried firewood up to the house, right?
Carried firewood, I don't know where, but he had helped her carry firewood.
Okay, and did you confirm that with Mr. Gumieni?
I did not.
Did anybody?
I don't know.
Now, there was some suggestion about the fact that this was in May that this fire, the videos we watched last week showed tremendous amount of wind blowing. Isn't that true in many of these videos?
Judge, I'm just going to object. My question was actually, there was an objection to my question. It was sustained. So now counsel's trying to take advantage of a question that I wasn't allowed to complete.
The previous question had to do with the fact that this was in May, that there was a fire. The fact that he was asked about a different issue is not what I'm getting into.
Well, the last question that the court heard was, wasn't there essentially a lot of wind that day?
Right.
That's the last question that the
Yes.
court heard.
Well, the buildup to that, though, was there was a suggestion on Friday that this was in May, and I'm simply pointing out that my question, which I tried to ask on Friday, there was an objection and it was sustained.
Well, that question had to do with the attire of an individual
That's correct.
who was wearing shorts.
Yeah, I'm not
And
asking.
so now this question has to do with whether, it has nothing to do with the temperature. It's whether it was windy.
Right.
So overruled.
So I can't quantify the amount of wind. I know that I heard some wind noise, but I can't say it was heavy wind.
When you were standing up there looking at the vehicles and illustrating vehicles going back and forth, you didn't notice that the trees were blowing and some looked like maybe, I'm not going to estimate, but in 10, 20, 30 mile an hour winds.
I don't know how much wind there was. I just know there was wind.
Okay. By the way, firewood burns white smoke, doesn't it, in your experience?
I have no idea.
Things like cloth burns, doesn't it?
Judge,
Well, the court's going to sustain the objection because this all requires essentially conjecture.
All right. That'll cross off 6 more of my questions. Let's talk about this issue with the coffee. We just watched this video where you asked Michelle about whether or not the paper towel that Dulos handed her to throw away smelled like coffee.
I remember
Recall
that.
that portion of the.
I certainly do, yes.
Now, I can't remember if it was you or Detective Clabby suggesting that this, coffee stinks and, it has a strong smell. Do you remember those questions in this video, in this August 13th
I do.
interrogation? Right. Didn't she tell you that she didn't smell it at all and actually gestured, she never pulled it up towards her face?
So when Detective Clabby asked his question, he gestured. In response to his gesture, she said, I didn't smell it. But if you watch at 3:07, she says, you're right, it did not smell of coffee.
You're telling me that she responded to what Detective Clabby said, and you know that how?
She did this, she made the same motion.
And she says, I didn't smell it. And she went like this, like she didn't take odor and whiff the rag. Isn't that what she said?
She didn't go through the act of smelling, but she later on said that those didn't smell of coffee. If you play 3:07, you'll see that.
So you know the exact minute that
I do.
this was said?
I do.
Why? Because you anticipated I was going to ask you that question?
Yes.
Oh, all right. I want to talk to you a little bit about the Tacoma key. You were asked, at least twice as I understand it, whether Michelle Troconis mentioned the Tacoma key prior to the August 13th, 2019 interview. You remember being asked those questions by Mr. McGinnis, and you said no, she didn't bring it up?
She didn't mention the key. Yes, I
You didn't ask her before August 13th about a key, did you?
No.
You did know that Mr. Mawhinney had said, well, maybe she just didn't want to leave a key in an unmanned vehicle when no one was home, or words to that effect. No.
She said that.
Didn't Mr. Mawhinney say that in his interview prior to August 13th?
Jack Judge calls for hearsay.
It's not being offered for the truth, it's the fact it was
Well-
said.
Since then.
Well, it is being offered for the truth because it's being offered to show that the account that Michelle Troconis did not know or had the key inside of the vehicle was contradicted in some way at some other point. So it is being offered for the truth of the matter asserted, so sustained.
In any event, I just want to be clear, you never asked her anything about a Tacoma key prior to August 13th, 2019, correct?
Correct.
Or the fact that she brought it back like 5 minutes later, 7 minutes later?
No, we didn't talk about that.
I can't hear you. sir.
No, we did not talk about that.
With regard to the Russell Speeder car wash, in all of the surveillance video from that plaza, at no point do you see Michelle Troconis anywhere near the Russell Speeder car wash, correct?
I didn't review the video, so I don't know if that's accurate.
Detective Clabby went in, didn't he?
I was not even here for that, so I believe he did go in, but I was not in state for that.
You mean on August 1st, you weren't in state on
No,
2019?
No, I was on a vacation.
Oh, you were on vacation. You knew, you were the chief investigator, though, for this investigation, right?
Yes.
And so you would review what other officers did in this investigation, right?
In general, yes, but I don't know the answer to that question.
Particularly if you were going to apply for an arrest warrant, right?
Yes.
So you also know that you had specific knowledge that Detective Clabby had spoken to the personnel at Russell Speeder, right?
Yes.
And he also wrote, and you knew that the double entry of a phone number was a clerical error on the part of the employee, correct?
Double entry?
Yeah, the fact that Miss Michelle's phone number was written next to a Toyota Sienna at 8:44 a.m. that had a full detail for $250, right?
That's the way that Fotis Dulos entered the information.
Now, didn't Detective Clabby write a report that said that was an error on the part of the person that worked at Russell Speeder on August 1st, 2019?
There's an objection.
Objection, hearsay.
Well, here's how the question is developing. First, the witnesses said the witness was on vacation. And then the question was, well, you review the reports of those who you supervised, and the answer was in the affirmative. And then the question was, didn't Detective Clabby indicate that there was an erroneous entry on the log with Michelle Troconis' phone number next to a Toyota Sienna, which had been detailed for $250. So the question, didn't you become aware that Detective Clabby noted an error in the log detailing what happened with a Toyota Sienna next to Michelle Troconis' phone number, price $250? Well, the question is, did he read a report by Detective Clabby that stated that? That's the question.
Well, was he told it, not whether he read the report?
It's double hearsay.
It's not being offered for the truth. It's the fact that it was the effect on this listener.
Well, this court sees that question as a simple question. Not whether he was told, because the court would sustain a hearsay objection. If this witness has testified as a result of counsel's question that he reads the reports of all of those he supervised, did you read a report in which Detective Clabby said there was an erroneous entry at Russell Speeder's car wash? That's the question. If that's the question, the objection's overruled.
You ask a question?
Did you review a report that indicated that the entry regarding a Toyota Sienna at 8:44 a.m. was an error recorded at Russell Speeder?
I saw no report that stated that.
Because didn't you swear under oath as late as January of 2020 that it was Fotis Dulos who dictated the 8:44 a.m. entry of a Toyota Sienna?
Judges object at this point, improper impeachment, hearsay.
Well, the question is, didn't you, that is this witness,
Right.
indicate that that note, really the log, said whatever it said? And so the question is, has this witness ever said that the note contained certain information? That's how the court hears the question.
Right.
Again, she asked the question for me.
Did you write an affidavit stating that it was Fotis Dulos who gave the information that he had a Toyota Sienna at 8:44 a.m. as a log entry to Russell Speeder Car Wash?
I wrote that because that was my understanding at the time.
But you knew at that point when you wrote that Detective Clabby had determined it was an error by the Russell Speeder employee, correct?
Incorrect. I did not know that.
You did not know that. You knew that now, though, right?
I have yet to see the report.
Well, the court is trying to understand what the ID marking means. This witness has said that he didn't recognize that that Toyota Sienna entry was erroneous at the time, but now he does. And he included that in an affidavit. So that's been admitted.
Well, he didn't admit, I didn't hear him admit that he now knows it was erroneous. If he is, then I don't need to do this. Are you admitting that that information was erroneous now?
I would need to see the report to determine that, sir.
Right, well, that's where we're at, Your Honor. Could I have a...
In this court's view, it's a very simple, essentially demonstration. If Sienna is in the report, then the witness can indicate that's an error.
Just have before I show you this, when did you get back from vacation? Because I want to get the time frame.
Don't remember.
It was
Counsel?
before, obviously, August 13th, 2019, right?
Obviously, yes.
And Detective Clabby was in that room with you on August 13th, right?
He was?
And he informed you as to what had occurred in this development of the investigation while you were on vacation, right?
Yep, yes.
All right, so I'm going to show you what has been marked for ID as MM. And so you don't have to read the entire report. I'm just going to have you start with right here. Yep. You had a chance to review that, right?
I did, yes.
Detective Clabby informed you that the entry regarding the Toyota Sienna was entered in error. Didn't he tell you that?
No, he did not.
He never told you that.
I did not know that. No, I wouldn't have put it in affidavit.
Okay, so that was an error that you didn't know at the time. So it was a mistake that you didn't know about.
Correct.
Okay.
It's 3:20, we're going to take our afternoon recess. Ladies and gentlemen, please do not discuss the case.
All rise. This Honorable Superior Court is now open back to session. Good afternoon, Your Honor.
Good afternoon, please be seated, thank you.
Judge, before the jury comes out, I just wanted to play something on the record. The state's, except when they're playing the video, the state's direct of this witness from both Friday, from all of Friday, including, I think, Thursday when he started, or whenever he started, all had to do with what other police told him. When I objected on hearsay grounds, and the state said, well, it goes to the effect on his investigation, the court overruled my objections. What's happening, though, I just want to be, for the record, is that when I'm pointing out things that are essentially exculpatory that they learned during the investigation that they didn't follow up on, it's suddenly hearsay and it's being sustained repeatedly. So I'm noting that the same grounds that was allowed that allowed this witness to testify as to what others told him was permitted, and now it's being precluded on cross-examination. I think it's like I think the case, the one to cite would be Wardius versus Oregon 412 US 470, which basically says that when rules are applied differently to the state versus the defense, that it becomes a due process violation. So what's happening is anything that was consistent with their narrative, hearsay was allowed in, but I'm pointing out all these things that this witness knew or learned during the course of the investigation prior to August 13th, and it's being excluded on hearsay grounds when it's not being offered for the truth. It's being offered to show that he knew these things at the time of the investigation. So I just want to put that on the record. You know, I'm almost done, but I wanted to at least state on the record my concern.
Well, here's the difference. The court, first of all, is not going to revisit its ruling, but here's the difference. In the interviews, it is not always clear the reasons the interviewers are asking the questions. So what is clear is that they're asking questions in order to get a response from the defendant. They're not asking questions, and those questions coming in basically based on hearsay information to prove the matter asserted. They're asking questions to get a response. Some of the questions are genuine, some are disingenuous. But the purpose is to get a response from the defendant, whether the information that they conveyed was basically hearsay information or not. In counsel's questions, for example, counsel asked the question, well, did you find out to this particular witness that there was actually a coffee cup in the garbage at 80 Mountain Spring? That's not to get a response from the witness. That's to prove that there was a coffee cup in the garbage at 80 Mountain Spring. The questions that are based on hearsay asked during the interview elicited responses whether those questions were genuine or not. That means whether they were truthful or not. In this court's view, the questions asked by counsel essentially are efforts to get in hearsay statements for the truth of the matter asserted in those statements. That's the difference.
Judge, can I also just be heard on an issue very
Yes.
briefly? Judge, at sidebar, I had raised an objection to one of Attorney Schoenhorn's questions earlier because essentially Attorney Schoenhorn asked a question for which there was no factual basis to ask. Specifically, he asked Detective Kimball, isn't it true that, and words to this effect, Judge, because I don't remember the exact question, that by August 13th, you would have known that my client's phone records showed a incoming call from Enterprise Rental. And I pointed out at sidebar on May 28th, and I pointed out at sidebar that those particular records, which were subsequently suppressed, only went until May 27th. So there was no factual basis for that particular question to assume that the detective would have known that on August 13th. When I raised this at sidebar, the defense's response was you didn't basically object fast enough. And I just want to know, and the state incidentally the other day had the fortitude to say that we had made an error when we asked a question and we moved to strike. And I want to know if the defense is similarly going to say that they made an error in that question and the state will join in their motion to strike, because that was not an appropriate question. There was no factual basis for it.
I'll just say, I don't even know for a fact that that those records only went through May 27th would be, what, 1 day or 2 days prior? No, 1 day prior. This is may know that, but I'm not willing to say that without knowing that that's the date that we're talking about. I thought the records were through May 31st, personally. So I don't have those records here to know that, in fact, they didn't include the next day.
We just litigated this the other day, and I pointed out to the court that this warrant application, which the court indicated it was not going to grant the defendant's motion to suppress, was different in that the previous application only went until May 27th, and this application went the week before and the week after. So when counsel says he didn't know, I'm surprised by that comment, given that we just litigated it the other day. And so I'm once again asking, are they going to have the fortitude to move to strike that question and answer in front of the jury?
Well, this is not going to be essentially a test of any counsel's fortitude, moral or otherwise. This court responds to objections as they are made. So it would not be possible for this court to know at any particular time, having this being almost the fifth complete week of testimony, whether something constituted facts not in evidence. So again, this court will rule on objections in a timely fashion when they're made, in a timely fashion. Can we bring the jury out? Would counsel stipulate, please?
Yes, Judge. Yes. Officer Kimball, I just want to maybe correct. I referred earlier when I was asking about the call to Enterprise to AT&T Records, but you in fact had other information that you confirmed that she did in fact have to pick up her car that morning from Enterprise rental car, even if it wasn't from her phone records, correct?
I don't know what other, I don't know.
You actually, somebody went to Enterprise rental car to confirm that when she rented that vehicle, right, the Yukon?
I believe so, but I don't have, off the top of my head, I don't have
And you
recollection
had
of that.
other phone records of my clients from the phone that you knew that she'd received those calls that morning, that call at 9:15 from Enterprise, right?
I don't know that.
Okay. Let me just, I'm going to finish up on, I just have a few more questions about Russell Speeder. Michelle told you that she dropped off, that she picked up Fotis Dulos at the Russell Speeder after he went in, right? In this interview, correct?
Yes,
That she told you she never went in, right?
yes,
She told you she didn't even know he had paid with cash, right?
yes,
And she told you that when she picked him up, they went right down to see Attorney Bowman down in Westport, right?
yes,
One of the other things towards the end of the interview, you showed Michelle a picture that we see in the video of another woman with Fotis Dulos that one of you refers to as Michelle 2.0, I wrote down, right?
It was not me that did that, it was Detective Clabby.
Okay, but you were the one who showed her the picture, right?
Correct.
And that was a picture of a woman, just so we're clear, named Anna Curry, right?
That's correct.
And this is the woman that moved into Fotis's house a short time after Michelle moved out, correct?
That's my understanding, yes.
And the picture you showed her, which hasn't been offered, but it showed Miss Curry together with Mr. Dulos at a store, right?
Yes.
And you said one of you said that the woman looked a lot like Michelle, right?
Yes.
You thought, or one of you thought it might in fact be Michelle? This way you asked the question.
Not at the time that we showed it to her, no.
All right, so you showed her that picture knowing it wasn't her, right?
Yes.
You showed it to her and told her it was Fotis's, I guess, new girlfriend, right?
I don't know that we said that.
Well, a woman he was now with that looked like Michelle, right?
There was similar appearance, yes, absolutely.
Tall, maybe similar build, similar hair color, things like that.
Yes, correct.
And was the purpose of showing her that to, what, make her jealous?
Purpose was to find out if she knew who that was, if she was familiar with that person solely.
But didn't you know by then that it was Anna Curry? You had
We
checked
wanted to
her
know
out.
if she knew who it was.
Oh, okay. And she didn't know who Anna Curry was, though.
That is correct.
Right? And you know, Anna Curry is the person who posted Fotis Dulos' bonds, right?
Yes, that's my
And you knew that
understanding.
she had become his, at least she was his move-in girlfriend, right?
Judge
I
is
did-
going to object hearsay.
You be-
Sustained.
You believed she was his new girlfriend, right?
Our understanding is that she was living at Fort Jefferson with him.
And she was living with Fotis Dulos at the time of his death, right?
Judge, objection, hearsay outside the scope.
Well, it's outside of the scope. Sustained.
Who asked the question whether or not that it might be by design that she looks like you? Who asked that question?
Well, first of all, that's not a question.
Well,
I don't know who said that. I'm not sure who said that, but it's not a question.
the statement that was made to her, I'm saying that suggesting that it might be by design that she looks like you don't know who that is. What was the reason for that statement being made at that time to Michelle?
I don't remember who said it, so I can't speak to that.
Did you suggest, or was it Mr. Detective Clabby who said that maybe he's trying to set you up?
I remember that being said. Again, I don't remember who said it. I don't
In
remember
any
which-
event, you knew that wasn't Michelle in that picture at the store, right?
Correct.
And then I'm just going to ask a couple more questions. Now, when Michelle indicated to you that on the morning of May 24th, she had gone to the Stop and Shop, correct?
Correct.
And she reiterated that during this interview, correct?
Correct.
You actually had a copy of the receipt from the Stop and Shop showing, in fact, what she had bought and when she had bought it, right?
I didn't have one in that interview.
But you had it, pictures were taken of it, that you had seen what the evidentiary services people took pictures of, right?
I don't remember whether pictures were taken of it.
All right, I'm going to mark this for ID. And just to set this up, you were aware that between the second interview of Michelle Troconis and the third in August, the evidentiary services unit had also been to Fort Jefferson Crossing, right?
They had gone between the first and the second interview.
No, they went on the 3rd of June, didn't they, to Fort Jefferson Crossing? They had been at 80 Mountain Spring on the 2nd, right? Just trying to refresh your
So-
recollection.
The 3rd of June is between the first and second interview. right?
You're right and I'm wrong. Yes, they'd gone between those two interviews, correct?
That's
And at
between
some-
interviews 2 and 3.
Yes.
Or 1 and 2, excuse me.
Right, and you're aware they took pictures of a lot of documents, right?
Yes.
And we already saw today the timeline, the photocopies of the timelines, correct?
Yes.
I don't have an objection to this offer. Do you have a color? Okay.
I printed it off there. That's okay. So, my exhibits. So, Exhibit NN is full. I'm just going to show you. There are a couple of receipts. You were aware that the Evidentiary Services Unit had taken pictures of documents they found in the house, right?
In general, I'm aware of that, yes.
Right. And you'll see that this side, I'll show you, is the Stop and Shop. There's a photocopy of the picture they took. So I'll just be clear. This is not the original document. It's just a photo of a receipt, right?
That's the way it appears, yes.
Yeah, and you'll see that it lists the address as
Bushy Hill.
Bushy Hill Road in Simsbury, you see that?
Yes.
And it shows that the time of the purchase was May 24th at 10:01 a.m., correct?
I see that, yes.
And it shows she bought stuff at the cheese shop, the deli, the produce, and then it says seafood, it says SB, raw, 2 pounds, maybe that's sea bass, I don't know, but you see that there, right?
I see that, yes.
And that she used her American Express card to pay for that, right?
Yes.
And on the same photograph, they also took a picture of the Starbucks receipt, right?
Apparently.
And that was the May 24th at 7:59 p.m. It shows exactly what was purchased at the Starbucks, right?
Yes.
And specifically also included that she paid with a MasterCard, right?
Yes.
And there was also officers viewed video of the of Michelle entering the Stop and Shop, correct?
Yes.
Add this mark, please. And showing you what's been marked as Exhibit 00. Is this a screenshot from the video of Michelle Troconis entering the Stop and Shop to do the purchase of the parsley, the cheese, and the sea bass that we just saw the receipt for?
It appears to be, yes.
And I'll just note, the time up at the top, that would be UTC time, 1:30,
Okay.
right? So if
I don't know that
you
for a
subtract 4 hours, that would be 9:30 a.m.?
9:31.
And that would be consistent with her actually paying for her items at 10 a.m., correct?
It would be, yes.
I'd offer it.
I have no objection.
What, is it NN?
This is 00.
Admitted as full.
And I'll just show it to the jury. And again, it shows Ms. Troconis talking on the telephone, or appears to be having her phone up at her ear as she enters the store, correct?
That's what it appears to be, yes.
Okay. Can I just have a moment, Your Honor?
Yes.
I just have a couple of just follow-up questions. You had previously testified that you had become the lead investigator sometime between the first and the second interviews in 2019, is that correct?
I don't remember testifying that. I'm not sure what date I was made the lead investigator.
All right. But in any event, you were the lead investigator as of August 13th, 2019,
Yes,
right?
that's true.
And so that any decisions that were made regarding moving forward on investigation or making arrests was made by you in consultation with others, correct?
It was made by my sergeant In consultation with me. but my-
And with the state's attorney's office,
And with the
right?
state's attorney.
Okay. So you couldn't do any of this just on your own, right?
Absolutely
So
correct.
this was a collaborative effort on your part with your sergeant and the state's attorney?
Correct.
Mr. Colangelo at the time, right?
Correct.
I have no further questions. Thank you.
Detective Kimball, on cross-examination, you were asked about K-9 units searching various areas, is that correct?
Yes, sir, that's correct.
A K-9 unit involves what type of dog?
Generally, a German Shepherd tracking dog.
Okay. And they were apparently looking for Jennifer Dulos, is that correct?
That is correct, yes.
As of today's date, February 20th, 2024, has Jennifer Dulos ever been located?
Objection outside the scope of cross.
It's outside the scope. Sustained.
During those K-9 unit searches that you were asked about on cross-examination, was Jennifer Dulos ever located?
She was not, no.
You were asked on cross-examination about the fact that it was actually the defendant who brought to your attention in the third interview that she had answered Mr. Dulos' phone. Do you recall those questions?
Yes.
What did the defendant say about Mr. Dulos' phone on June 6, 2019?
I asked her, she knew where,
Objection asked and answered.
Well, the question, the preliminary question was, in the interview on August 13th, it was the defendant who stated that she responded to the call of Mr. Dulos' phone, or on Mr. Dulos' phone. The next question is, what did she say on the 6th of June? Well, there's been a significant amount of testimony in this case. If it has been asked and answered, it may be difficult to recall that it has been asked and answered, so overruled.
What did the defendant say about Mr. Dulos' phone on the 6th of June when you interviewed her?
during that second interview, I asked her if she knew where Fotis' phone was. And her response was, with Fotis, I suppose. I asked her if it would be unusual if he left his phone behind, and she said it would be.
So she didn't say anything on June 2nd or June 6th about answering the phone, correct?
Not at all, no.
You were asked on cross-examination and shown video of a vehicle arriving at 4 Jefferson Crossing at 7:21 a.m. on May 24th, 2019, correct?
Correct.
And you were asked on cross-examination who that vehicle belonged to, correct?
Correct.
Who did that vehicle belong to?
Mawhinney.
You were also asked on cross-examination whether or not there was any video of Mr. Mawhinney's vehicle leaving 4 Jefferson Crossing, correct?
That's correct.
I'm just going to play judge if I could. It's from State's Exhibit 90. So this is State's Exhibit 90. There's a video entitled Swanson Video 4. I'm just going to play this video. Detective Kimball, I'm just going to direct your attention to the driveway of 4 Jefferson Crossing.
Okay.
Does that appear to be Kent Mawhinney's vehicle leaving?
It does, yes.
Could you note the time for the jury?
8:44 a.m. on the 24th of May.
You were also asked on cross-examination whether or not you had arrested Kent Mawhinney in connection with this incident. Do
Yes.
you recall that question?
I do.
What did you arrest Kent Mawhinney for?
Kent Mawhinney was arrested for conspiracy to commit murder in connection with the murder of Jennifer Dulos.
And are those charges still pending?
They are still pending, yes.
You were asked on cross-examination whether or not someone named Andreas was ever spoken with. Do you recall that question?
Yes, sir.
And what's Andreas's last name?
To the best of my ability, it's Tsiartas.
And did he wish to cooperate with the investigation?
He did.
Objection, hearsay.
Well, the testimony has already been adduced that the gentleman declined to cooperate, so overruled.
Did he cooperate?
He did not cooperate, no.
You were asked on cross-examination about what, if any, evidence was located at 80 Mountain Spring Road. Do you recall those questions?
Yes.
And I believe you were specifically asked whether or not there were any cleaning supplies or garbage bags located at 80 Mountain Spring Road. Is that correct?
Yes, that's correct.
Were there garbage bags located in the trash on Albany Avenue in Hartford?
Yes, there were.
And they were black, correct?
They were black, yes.
Was there a sponge located on Albany Avenue in Hartford?
Yes, there was.
Was there the handle of a broom or a mop located on Albany Avenue in Hartford?
Yes, there was.
And who indicated to you that they had brought cleaning supplies to 80 Mountain Spring Road on May 24th?
Michelle Troconis did.
Was there also a towel found on Albany Avenue in Hartford?
Yes.
You were asked on cross-examination whether or not the defendant had ever been asked about the Tacoma key or the fact that she had brought it back to 80 Mountain Spring Road in either of her first 2 police interviews. Do you recall that question?
Yes.
On June 2nd, 2019, when you interviewed the defendant, were you aware that the Tacoma had been at 80 Mountain Spring Road?
We were not, no.
And did the defendant share that detail with you?
She did not.
So how could you have possibly asked her that question?
Exactly.
Objection, argumentative.
Well, the answer to that question is self-serving, sustained.
Did she share with you that the Tacoma was at 80 Mountain Spring Road during the June 6th interview?
No.
Incidentally, you were asked whether or not on August 13th, 2019, if you were aware of surveillance footage showing the Toyota Tacoma leaving at approximately 5:30 or so in the morning. Do you recall those questions?
I do remember.
When was that surveillance footage located by state police personnel?
Towards the end, middle or end of November of 2019.
So after this interview, correct?
Correct, after the August 13 interview.
You were asked some questions on cross-examination about affidavits that you submitted in support of warrants in this case. Do you recall those questions?
Yes.
Detective, could you maybe characterize the nature of this case in terms of the amount of information that you were receiving as the lead detective?
Objection, vague.
Well, the question, can you discuss the amount of information you received, essentially in preparation of affidavits? There can be a very short answer, such as tons. And that's what the court expects. So it's the court doesn't want to preempt the examination, but that's what's coming. So the court's going to allow that question. The objection is overruled.
Maybe I'll just rephrase, I'll try to short circuit this, use the judge's word. Was it tons of information?
Tons. It was a huge investigation.
You were asked on cross-examination about the log entry at the car wash. Do you recall those questions?
Yes, I recall.
And I believe you were given an opportunity to review Detective Clabby's report. Is that correct?
That's correct.
And you were then asked whether or not the first entry on the log was incorrect. Is that correct?
That's correct.
But there was a second entry as well, correct?
There was, yes.
And that was mentioned in Detective Clabby's report?
Yes, it was.
And was that correct?
That entry was correct.
If I could just have the log. Terry, man, do you recall what number that is?
One thirty-eight. Takes a second.
So, Detective, you had an opportunity to review Detective Clabby's report, and you were asked about a wrong entry and a correct entry, correct?
Yes, correct.
All right, I'm just going to ask if you could just step down and, based on what you read in the report, can you indicate to the jury what the correct entry was?
Correct entry appears to be on this line. This is Michelle Troconis' phone number. The vehicle description is blank. The time is 9:14. Times 2 is detailing times 2. And this is the price which needs to be paid. In other words, it's not paid at the time of conception.
I want to just direct your attention to earlier on in the interview. I don't have the exact timestamp. And you were asked some questions on cross-examination about the smoke from the chimney. Do you recall those questions?
Yes.
All right. Now, you spoke with the defendant about her movements back and forth between 80 Mountain and 4 Jefferson Crossing during the third interview, correct?
Correct.
And at one point, you indicated to her that you were trying to figure out basically what she was doing to try to account for her time, correct?
That's correct, yes.
And at that point in the interview, did the defendant ever say to you that she had lit a fire at that point?
No.
She mentioned maybe being on her computer, I think, correct?
Yes.
If I could just have a moment, Judge?
Yes.
Nothing further, Judge.
So I just want to be clear, you just said that you didn't get any of the 77 Mountain Spring Road surveillance before the August 13th interview, is that correct?
I'm not saying that, no. I don't remember when we got that
Was it,
surveillance.
when I mean the video from across from
Right,
80
from
Mountain Spring?
77 Mountain Spring Road, looking at 80. I
Yeah.
don't remember when we retained that video.
Oh, so it may have been before the August 13th interview.
It may have been.
In any event, you know, those are the videos you narrated last week, right?
That's correct, yes.
You can't tell who's driving any of those vehicles from watching the video, correct?
No, we just know because of your defendant, your client telling us who was driving them.
All right. But other than that, you can't tell just by watching it, right?
No?
You can't tell what's inside any of those cars either from the video, can you?
No, you cannot.
Or who's bringing what at what point, correct?
No, we have to rely on her description.
There may be one additional question. Hold on. So as I understand it, the only way you had any knowledge as to who were in those vehicles going back and forth was from what Michelle told you, correct?
We saw individuals walking at along the ribbon line. So yes, it's essentially yes, the answer to your question.
All right, thank you. No further questions.
I have nothing on that, Judge.
Detective Kimball, you may step down.
Thank you.
Judge, that concludes our presentation for today.
Are there witnesses expected by the state tomorrow?
We have one witness in the morning, Judge.
And approximately how long do you think it will take on direct for that witness?
10 to 15 minutes.
Thank you. Will the defense be ready to call any witnesses if the defense intends to call witnesses tomorrow?
Yes, there are obviously some matters at the close of the state's case that have to be taken up outside the presence of the jury, but yes.
Okay, thank you. So, ladies and gentlemen, we will reconvene tomorrow at 10 o'clock. Thank you for your attention. Please do not discuss the case nor follow media about the case. Have a good evening. The testimony of Attorney Rose, that motion was signed by Attorney Patrick Jennings of the Met Law Group. Court is going to have to take up that motion to quash tomorrow. So we are going to begin tomorrow before the jury comes in at 9:30.
Your Honor, I spoke to Attorney Ment yesterday. After discussing with him, I just got notice about the motion. I didn't receive it yet. He said he faxed it to my office, but of course, I'm here. After speaking with Attorney Ment, we do not, I think a lot of it, I don't want to speak without actually looking at the motion, but since he verbally told me what it was about, I don't think it's going to require any kind of a hearing. I don't anticipate, in light of Your Honor's previous rulings, we're not going to get into the custody hearings that took place in May of 2019 in the divorce court. because the court has already made clear that that's not admissible. So I already told that to Attorney Ment, and I don't anticipate getting into any privileged communications between Mr. Dulos and his lawyer. In evidence already, there are certain communications, some of which involve Mr. Rose, and I'm just going to have him identify them and when they were sent. I can ask him about any advice that was given to him in a legal sense. So I think Attorney Rose will be on the stand for maybe 20, 25 minutes just to confirm when things happened and in what order they happened, and that's basically it.
Well, in this court's view, that wouldn't take 25 minutes. So what actually do you intend to elicit from Attorney Rose?
Until I speak with I was given permission to speak directly with Attorney Rose, and until I do that, I can't represent exactly, but there were certain text messages back and forth. The one that comes to mind that I know I would be getting into is about his haircut.
Well, the court will consider, after you talk to Attorney Rose, arguments tomorrow, but it would appear to this court that it would be a pretty thin direct examination. If the only questions concern when things happen, in other words, when there were filings, when did Fotis Dulos come to your office, that shouldn't take much time at all. But what the court will indicate is that any testimony elicited concerning what Fotis Dulos's reaction was to anything is not going to be permitted. Because even if it was not verbal, any nonverbal assertion is still communication.
Well, I want to at least be heard with regard to that, Your Honor. It's not a privileged communication, even if it's a communication. A laugh is not a privileged communication, for example. But Your Honor is basically saying that I can't even indicate whether someone appeared happy after there was a particular document filed. So I just don't agree, but that doesn't necessarily, I haven't gotten into that, so we're talking about the court precluding something before I even know to what extent that it's going to be elicited at this point. Your Honor already heard, if you recall, from Attorney Rose, and he was very careful during the suppression hearing on what he could and couldn't say. But I don't know if Your Honor's ruling now is broader than what Attorney Rose testified to at the suppression hearing.
Judge, if I could, may I be here? Yeah. So just, Attorney Schoenhorn's not prepared to represent what he intends to elicit. I don't think the court is precluding anything at this point. I think the court is just simply sharing its concern about the potential to dive into attorney-client privilege. So I don't think there's been any proffer or ruling at this point that we need to really debate. At least that's the state's view. I did just want to be heard on one additional matter, Judge. Kent Mawhinney, of course, is a co-conspirator in this matter. He's been arrested. The charges remain pending. He undoubtedly has a Fifth Amendment privilege and therefore is unavailable to both parties. And given that we're going to be resting tomorrow, I just want to indicate that for the record because obviously there shouldn't be any sort of missing witness arguments in closing argument under Secondino, I think is the name of the case, in light of that fact because he's unavailable.
Of course, unavailable does not mean he's missing. Unavailable means he's going to invoke his privilege. The court just wants to also go over how it intends to proceed for the schedule. So tomorrow morning at 9:30, we'll take up the motion to quash or, in the alternative, issue a protective order. Then the court expects the short state's witness cross-examination. And what the court understands is that that is the prosecution's last witness for arresting. Is that correct?
That's correct, Your Honor.
Then the court would expect the defense, if it intends to call any witnesses, to call witnesses. After the defense rests, now the court understood previously that the defense is probably going to take 3 days. That's what the court understood. Is that accurate, Attorney Schoenhorn?
Fairly accurate. I'll also note the court's leaving out, I'll file it now even though it's premature. I'm going to file a motion for judgment of acquittal, just a pro forma motion. I thought the state was resting today, so I'm filing it because it's got today's date on it, but obviously I won't argue it until after the state rests. But that will take maybe 45 minutes, 30 to 45 minutes, have case law and whatnot to cite to Your Honor, and there's a lot of charges, so I at least want to, it's not just a pro forma argument, I would believe, in this case.
Thank you. So after the state rests, of course, motion for judgment of acquittal has to be heard. Then the defense puts on its witnesses. I don't know how many witnesses the defense will get to tomorrow, but let's jump ahead to after the defense rests. The court is going to have to collapse certain things because what has happened in this case is uncommon. After the defense rests, we're going to take a break in order to allow both counsel to prepare their presentation for the contempt hearing. Now, the court does not know if all of that can be done the same day, but that's going to be the order right now. The court did not want to proceed with a contempt hearing interrupting the defense case. It's only after the defense rests. The court will indicate today that the contempt hearing, if a contempt finding is made, is not going to impose a sanction at that time, because that is a sanction that would be imposed, if there was one to be imposed, before closing arguments, and the court does not want to essentially disrupt the defendant's Sixth Amendment right to a defense. And in this court's view, having practiced criminal defense for a long time, would find it disruptive if the court proceeded with a contempt hearing, made a finding, and then asked counsel to prepare closing argument. Too disruptive. That's how the court intends to proceed. And then, of course, we'd have to proceed with a charge conference. So there are many, as the cliche goes, moving parts here. The court wants to try to make sure that the jury is not surprised and informed that, well, we're going to be here a lot longer than March 1st. So that's the reason the court has to proceed this way. If there is a finding of contempt, if there is a finding of contempt, sanctions will be imposed when a verdict is returned, whether it's guilty or not guilty. on all of the counts. Tomorrow, 9:30, we'll take up the motion to quash.
Is the attorney that filed the motion going to be here? I mean, it's,
The court does not know.
have they been notified? Because I
Court
would
does
say
not.
that,
The court does not know. This was just handed to the court right before the court came into the session.
there's one other thing I did want to at least bring to Your Honor's attention. Attorney Felsen and I have decided that in light of the nature of that allegation, that it would be inappropriate for either of us to represent Ms. Troconis, and then she has been reaching out to other counsel who will be, depending on when that hearing is scheduled, would be coming in. It's just, whatever happened during my cross-examination of one of the state's witnesses, and I just don't think it would be appropriate for us to represent her to the extent that puts us in a position that's certainly, I'm not going to say it's adverse to our client, but certainly puts us in a position where we may have information that is outside of what would normally be what you'd represent a client for. And the fact that there were prior counsel and all these other things that have to be investigated, so.
Do you wish to be heard, Attorney Matt?
On an unrelated matter, Your Honor, with respect to the fact that I just make a request of the defense and bring it to the court's attention that throughout the course of the trial, the state the night before has given the defense attorneys list the names of individuals who will be testing the next day. The state is asking for that same courtesy. So counsel could indicate which witnesses will be testifying tomorrow. I know there are experts coming from out of state, so the state would like to know which ones to prepare for tomorrow.
Neither for tomorrow, Your Honor.
If I may know who is testifying
Sure,
tomorrow.
once we're done, I'll just tell her.
Thank you.
Thank you. If there's nothing else, we will stand adjourned until tomorrow morning. The session will start at 9:30.
Thank you.
Thank you. We'll stand adjourned.
All rise.